Good morning or good afternoon, everyone. Thank you for joining us this afternoon, where we are. Just to introduce and remind you very quickly of who we are and what we intend to do in the hour which we are going to spend together. The idea is that this webinar will last for 1 hour. ecoDa is, as it says, the European Voice of Directors. We are the Confederation of Directors Institutes in Europe. And we have been in part concerned for the last year, and more precisely since February 2022, when the European Commission sent around this proposal for a corporate sustainability due diligence directive. And as an organization of directors, we were concerned about what the possible impacts would be on the directors' responsibilities or duties and liabilities. And this is why we've decided to launch a survey in pairing with Allen & Overy, which is a prestigious English-based law firm, which has offices in many European countries, in order to check out what the situation is today in respect of directors' liabilities, because, of course, it's a question of civil law and criminal law, which is regulated by national laws, and therefore we suspected there may be big differences. And we thought it would be extremely important to know where we stand for the time being, and whether with this variety of backgrounds, what the liability of directors are, because everybody knows that they are not unaccountable, they have a form of liability already. And then that will allow us to see whether the CSDD, as it is called, the Corporate Sustainability Due Diligence Directives, when it is enacted and enforced, whether it's going to change the situation. So very briefly, we have organized this webinar to start with in two parts. One will be the first will be presented by Gauthier Van Thuin, who's a partner in the Brussels office of Allen & Overy, and who's in charge of the Sustainable Supply Chain Regulations, which is certainly a title that was not used in law firms a few years ago, which shows that we are, if not, we are going with our time, and perhaps even ahead of our times. So he will explain what the CSD is, what the purpose is, and what we can expect from this from this act when the rather painful laboring delivery, which is undergoing at the moment, is over. And after that, we'll turn to Bart de Bock, who is a litigator in the same firm, and therefore somebody who's very well aware of the issues of liability, civil and criminal, and he will try and tell us what the outcome is of our survey and what is the situation today about directors' liability and what changes may occur if and when the CS3D is enforced. So with no further ado, I give the floor to Gauthier so that he gives us tries to clarify a little more what is the is in the CS3D, and where we believe it stands in the middle of this discussion, which is between the three organs of the of the European Union, which is called a trilogue. So Gauthier, over to you.
Oh, thank you very much, Pascal. Maybe a word of advice to the audience when you see this opening slide. Fear not. I will not go through the whole of the CS3D in the 10 or 15 minutes I'll be spending with you, but I will just try to touch upon the general background to the CS3D and then address a number of its more characteristic issues before handing over to Bart, who will look at the director's duties and director's liability. If you could go to the next slide, please. And I find it important to explain this slide because supply chain or value chain, depending on the definition you want to use, legislation is really on the rise, especially in the EU or in Europe wide, actually, also beyond the EU. And today we look at the CS3D. And although it has a number of very specific and maybe new and unique features, some of which may be related, but that's for Bart's part, on potential impact and definition of directors' duties, it's maybe important to understand that this type of legislation does not come falling out of thin air, because there are already at this stage a number of EU mandatory due diligence regimes under different environmental regimes. And there is 3 of them which may be of relevance, more or less relevance for some of your companies. There is the EU Complex Minerals regulation that looks at avoiding that the importers of tin, tantalum, tungsten, and gold would be sourcing their raw materials from conflict areas or from areas where you would encounter issues that are similar to the ones you see in conflict areas, and the focus is there on human rights, labor, forced labor, for instance. But there's also the very important deforestation regulation, which has been adopted in June of this year, and which will, as of December 31 of 2024, actually come to an actual ban of a number of products that are based on, have been fed with, or are made of 7 relevant commodities, which include cocoa, coffee, cattle, soy, palm oil, rubber, and wood. And that actually is a regulation which requires within the supply chain, either an operator or a trader, to provide due diligence, to bring evidence that none of the products are the result of deforestation, so the turning of forests into agricultural land, and have been won or have been harvested in line with local laws, which include, again, human rights and environmental rights. The same. And you see a similar rule in the mandatory supply chain due diligence in the new batteries regulation, where some importers and manufacturers of a specific type of batteries will need to provide evidence that they have a chain of custody, that they also are looking at where their critical minerals and critical raw materials come from, have a due diligence, and make sure they don't source in non-compliance with any local human rights or environmental rights. And so you see, this is really very much, I would say, the flavor of the month. It's probably even the flavor of the decade in the EU when you look at supply chain sustainability legislation. Now, that supply chain legislation in the EU coincides with a number of national requirements or legislative proposals. And I don't think it's useful to go through all of these examples. Most of you probably know the most famous or infamous example, which is the French Duty of Vigilance Act, which dates back to 2017 and which has already given rise to a number of very well-known and very visible types of litigation, specifically in France. But if you look, that Vigilance Act has been at the mind, I think, of the authors of the proposal for the Directive on Corporate Sustainability Due Diligence, so in short, CS3D. That is part of the Sustainable Corporate Governance workstream, and which will require, but I'll explain that in a few words later on, due diligence in relation to human rights and environmental concerns. The proposal, as Pascal identified, dates back to February 2022. The Council has issued a general approach November 30 of last year. The European Parliament has taken a position and negotiation mandate on June 2023 of this year. The trilogue discussions are pending, and the general expectation is that there will be a compromise or a number of compromise proposals expected by November or December of 2023, with an adoption in early 2024. I think the latest possible vote to be in February 2024 for the EP before the 2024 elections. Maybe if you could go to the next slide. Front and center of the CS3D is the idea of this mandatory due diligence, because the directive will, obviously it's not the directive, but the implementation in the member states will require and impose a due diligence obligation for in-scope companies that will need to identify and address the adverse impacts they have on human rights and the environment along their, I have here, value chain, and we'll come to that later, whether it's value chain or supply chain or chain of command, around 6 core measures that every company will need to comply with. integrate a due diligence into all companies' policies, including a code of conduct, identify actual and potential adverse impacts on human rights and environment. And that list of human rights and environment is annexed to the directive, already gives rise to a number of discussions, what is included and what is not. The third one is a very critical one, especially when you look at liability and potential directors' duties, is to prevent, mitigate, or end actual or potential adverse impacts, and to remediate actual impacts. Now, a few words of explanation surrounding that specific measure. It is an obligation of means for companies, where companies will need to adopt measures proportionate to the impact, not easy sometimes, focus on their most likely and severe impacts in their business relationship, and identify and list, actually map their most risk-related business relationships. And when it comes to remediating the actual impact, as the directive spells out, it actually could be, as a last resort, suspending or terminating relationships. But also keep in mind that that remediation, and in terms of liability, this may also give rise to a number of discussion, must be proportionate again, must be proportionate to the adverse impact's significance, to the contribution of a company to the adverse impact, and it must also be proportionate to the leverage a company has and the resources a company has. That will create, I think, a lot of issues if and when there will be any liability claims. The fourth measure in this central due diligence obligation is to implement an internal complaints procedure. Some of you who may be familiar with OECD guidelines or with the UNGP, United Nations Guiding Principles on Business and Human Rights, will also have seen already or may have adopted these internal complaints procedures. They're importantly in the EU, always you'd see that also in other elements, is the monitoring of the effectiveness and specifically the reporting, not in the same way as the CSRD, but the reporting is a very important aspect of this whole exercise. If you could go to the next slide, and for the next couple of slides, I've opted for the three ways. So see what the Commission proposed, what the Council's position is, and what the European Parliament's position is. And maybe not going to over all that much detail because that would take us too long. But at the core is the idea that the Commission launched of having very large companies, more than 500 employees, turnover above 150 million, and also companies with less employees and a smaller turnover, but in high impact areas. And that is important. High impact areas is where you have half of your turnover that is generated in textiles, fashion, agriculture, farming, food, beverages, extraction of minerals, manufacture of metal products, and a number of other potential high impact industries, that those already will be in scope, even if they would not meet the criteria for the very large companies. I would say typically EU, also non-EU companies are in scope if they have a net turnover in the EU of a certain amount. That is usually between the Council and the Commission pretty much allowed. You'll see that on the slide, it's 150 million. And then there's a question about the financial sector. In the Commission's proposal, it's in scope, but it's not very clear in the wording whether it's upstream and downstream. In the Council's proposal, it is, well, not in scope. It's actually up to the member states to define whether or not they want to keep it in. And as you'll see at the farthest part, the European Parliament, all those measures are more stringent and more strict, both in terms of the definition of the companies. So whether they're large companies or the large groups where the ultimate parent of a group has more than 500 employees or a net turnover of more than 150 million, but also when it comes to the financial sector, where they not only include the financial sector, but also look at institutional investors and asset managers. As Pascal explained in the beginning, there are still trialogue discussions going on. There may be some horse trading along the way. So none of this may be the actual final text, but it gives you a flavor of what the companies in scope would be. I'd like to spend also a moment with you on the next slide on this concept of value chain, chain of activities, or supply chain. And I said in the beginning, supply chain legislation is very much on the rise. The Commission came in this proposal with the idea, let's call it a value chain. And I understand that because it looks at upstream design, extraction, manufacturing, suppliers. It also looks downstream at distribution, logistics, waste management, transport, and what have you. But you'll see again, according from the source, whether it's the Council or the Parliament, a less strict or a more strict option. The Council, which is the representative of the member states, tries to move away from the whole value chain concept and says, let's call it chain of activities. And when we look at the upstream, yes, there is an important chain of activities that is relevant. But if you look at downstream, it should be limited to a number of downstream partners. first of all, only those partners that act for or on behalf of an in-scope company, so not down the whole supply chain or value chain. And also, it would exclude disposal of certain products. So that would be less in scope. The European Parliament that actually takes the same concept as value chain, but adds so many layers of value chain that it really becomes a very, very long value chain, much further than you'd see in anything of the Council and the Commission. And then maybe my final slide before we can really have a look with Bart into director's liability is the one on liability. Now, typically in European regulations or directives, and the CS3D is no different from others, is the idea that member states, according to their own law, may impose sanctions. But what is interesting from a legal point of view is the fact that Article 22 in this draft directive also looks at civil liability of companies. Now, if you look again, and the subtitles, initial scope, restricted scope, extended scope, is what you should expect from the different actors within the legislative process. But in the EC, so the Commission's proposal, companies will be held liable for damages if they fail to comply with Article 7 and 8. What are Article 7 and 8? They are the articles about prevention and bringing adverse impacts to an end, so prevention and remediation. If as a result of this failure, an adverse impact that should have been identified, prevented, mitigated, ended or minimized may have led to damage. If you look at the Council's proposal, that restricts that scope. It says that the company can only be held liable provided the company intentionally or negligently failed to comply with this Article 7 and 8. And if as a result of this failure, damage was caused, but with no liability, if the damage was caused only by business partners in the chain of activities. And finally, if you take the European Parliament proposal, there you'll see that companies could be held liable for damages if they fail to comply with the directive, actually in its entirety. That could also be about reporting, about other issues. If as a result of the failure, the company caused or contributed to an actual adverse impact that should have been identified, prioritized, prevented, mitigated through appropriate measures and led to damage. And it's important to understand this article because there are a number of elements you'd expect, and part of the real litigator, you'll know that much better than I do, but a number of elements you'd expect in civil liability regulation, but which are not in there. There's nothing about burden of proof. There's nothing about rules of compensation of damages. There's actually no rules on causation. But if you look at the European Parliament's proposal, they're scattered throughout the text, I should say, which is not always coherent. You see a number of additional elements, including limitation periods, the idea that costs to litigate must not be prohibitive, the possibility for having injunctive measures, including summary proceedings, but also, that's also important, right to claim for trade unions, for civil society, for organizing access to justice for NGOs or other parties acting on behalf of a class or a group of companies, and a duty of companies to disclose documents and cooperate in providing evidence, with no safe harbor also for companies that have participated directly or indirectly in multi-stakeholder initiatives, and actually also no safety or full safety for the use of third-party verification. Now you'll see that is an article that has, again, not talking about director's liability, but general company liability, a huge impact with a few, not a few, but many threads still to be knitted together into a coherent article. That would be my general introduction before handing over to Bart.
Thank you, Gauthier.
Thank you very much, Gauthier. Now, Bart, over to you. If you want to take us more deeply into the consequences of the director's liability, on director's liability of this directive in preparation, and start with explaining to us what the current situation is in the variety of European countries as a result from the survey that we have conducted.
Thank you, Pascal, as indeed. Let us zoom in on director's liability. And as you rightfully mentioned, it has become a hot topic, so to say, as a result of this wave of sustainability regulations, and especially in light of the CS3D, which is the reason, obviously, why we're having this webinar. And indeed, Ellen and Overy, together with ecoDa, we wanted to clarify in a bit more detail what director's liability exactly entails. And therefore, we concluded a multi-jurisdiction survey. And this survey on directors' liability covers the jurisdictions that are listed on the slide. It's 15 jurisdictions. And it is basically based on a questionnaire that covers topics such as the legal basis of directors' liability, the scope, the enforcement, the sanctions. And it also discusses the concrete actions that are taken against directors in practice. It highlights the key challenges and opportunities for directors in relation to sustainability and corporate social responsibility. And the survey will be published in the coming days. It will be for the week of 6 November, if I'm not mistaken. It will be announced on ecoDa's and Overy's website and on its LinkedIn pages. But for the purposes of this webinar, and we can go to the next slide for that one, we wanted to already share with you some high-level summary findings of the survey. We must admit it was quite a challenge to summarize the survey because the survey itself immediately shows that there are many different approaches to directors' liability across the various jurisdictions that we investigated. And it already starts with the governance framework. There is a large diversity of the governance setups available to companies in the jurisdictions. Some countries recognize a one-tier structure with a board of directors and then a management, or a two-tier structure with a supervisory board and a management board. But most jurisdictions give the option between those two forms. And also, most of the jurisdictions we investigated, there is also a setup with a sole director that is available and is mostly used for smaller companies, but also sometimes by larger companies, although they are then unlisted companies. Interestingly is the director's duties and responsibilities. So the laws generally specify a form of duty of care that is applicable to company directors. It is not always recognized under that name, duty of care, and sometimes it is also based on a different conceptual approach. But in almost all jurisdictions, directors are expected to exercise their mandate acting within a certain duty of care, within a duty of reasonable diligence. And this duty of care, is in general aimed at protecting, promoting the company's interests. And there is a lot of divergence as to how we define company interests. Sometimes there is specific mention of interests of shareholders, creditors, but also, and maybe more recently, also stakeholders. And the concept of company interests and the link with stakeholders is very relevant when we apply sustainability and CSR to directors' liability, which I will explain on the next slides. But we can go to the previous slide, sorry. Common feature that we see in all jurisdictions is the obligation of means standard for directors' duties. And the law really appreciates that the diligence standard that is expected from directors should be determined as reasonable. Directors are only liable if they do not act as normal, reasonable, prudent directors acting in the same similar circumstances, or that should have been done in the same circumstances. Another feature is, and that is not surprising, is that we see in all jurisdictions that there's a lot of emphasis on the prevention of conflicts of interest and detailed conflict of interest procedures in company law. If we turn to the liability framework, we see a widespread area of civil liabilities. It can be based on a breach of contractual obligations, so the contractual liability towards the company, and then claims can be made against directors on behalf of the company and can be pursued by the company's board, or in some occasions also by the shareholders themselves. And there is, in some jurisdictions, like in Belgium, for example, a minimum shareholding that you need to have before you can sue the director on behalf of the company. We see also liabilities in tort. This is not unusual. This typically follows the general principles of tort liability in the various jurisdictions. Criminal liability, as a minimum, we identified the general principles relating to fraud also apply to company directors, but sometimes there are more specific causes of indictment applicable to directors, such as misappropriation of company assets. In terms of limitation of liability, we identified in the survey that there is no real cap amount that is provided for by law, There is one notable exception that is within the jurisdiction that we are acting, and Gauthier and I are acting, which is Belgium, where there is a cap on liability, but the scope of that cap and the scope of application is very, very limited. In terms of indemnity agreements, when a company indemnifies the director for its liabilities, it is generally accepted in a couple of jurisdictions. But in other jurisdictions, we then see that directors even have to deposit a guarantee bond to secure their liability. Who can be held liable? Here we see usually no real difference in the legal framework as such in the various jurisdictions between executive and non-executive directors. So it's been legally treated the same, except in some jurisdictions we saw different rules for supervisory board members. But of course, in practice, their liability is completely differently applied. It's assessed differently because their duties, the duties of an executive or non-executive directors, are obviously not the same. De facto shadow directors are usually treated the same as formally appointed directors, and at least this applies for criminal liability. We also identified when legal entities are appointed as directors, it will be the natural person that is representing those entities that usually incurs the real liability. So there is indeed some piercing of the corporate veil being done by courts in the various jurisdictions. And then lastly, a point on joint and several liability for collective decisions. That's also quite a general rule, and it's also quite a general exception that you can escape from this joint liability if you as a director has expressly opposed the decision taken by the board. Very shortly on bankruptcy, we often see an enhanced civil liability towards the creditors if the director's actions have contributed or caused the bankruptcy. And we see a similar thing when directors are delayed in filing for bankruptcy. And also sometimes we identify specific criminal charges that are linked to bankruptcy cases. A last point on the slide here is the frequency of directors' liability claims in practice. So we asked in the survey how often directors' liability cases occur in the various jurisdictions. And it appears that in neither of the jurisdictions, there is actually a lot of statistics being available, neither on the frequency of the cases, neither on the amounts of damages typically awarded in those cases. But the general appreciation that stems from the survey is that the cases of directors' liability are quite infrequent, so do not occur a lot in practice. Turning to the next slide, one of the questions in the survey was about the impact of corporate social responsibility, CSR, on directors' liability, which is obviously the key topic of today's webinar. And a lot has been written about the necessary involvement of directors in order to create effective corporate governance and sustainability tools in today's corporate world. And with the new EU legislations on its way, it appears that sustainability is about to create a new dimension in the field of directors' liability. No express duties in EU legislation at this point in time. So indeed, as of today, the main focus in all sustainability and supply chain legislation lies on the companies themselves and do not so much focus on the directors of such companies. That being said, the significant increase in ESG-related obligations for companies are, or at least should be, an important concern, obviously, for directors in such companies. But the new legislation, very recent, so the CS3D goes one step further and also specifically targets company directors to make them personally aware of the sustainability obligations of the company and also to make them personally accountable for those obligations. And the new EU sustainability legislation, and regardless whether they target directors personally or not, is expected to have a considerable impact on the interpretation of the duty of care standard that is applicable to company directors and to their fiduciary duties in general. That is a general statement, and the case law precedents are actually limited as of today, but this may change in the future. We might have heard from the derivative claim from Client Earth against the Shell directors. It's a proceedings pending in the UK, where Client Earth asserts that the Shell directors would be breaching their duty of care by not properly managing climate risk. And the Directors' Liability Survey shows that the duty of care is not a strictly defined concept, but it is applied in a rather flexible manner, and that it varies significantly across the jurisdictions. In some jurisdictions, we notice that the duty of care is formulated quite broadly, with significant room for interpretation, but also for evolution. This is, for example, the case in Belgium, and we see that also in France. But it can be much more specific and limited in nature in other jurisdictions. And then we look at Spain and Slovakia. So there are significant differences as to whether directors owe a duty only to the company and or its shareholders, which we see in Sweden and Romania, or also to third parties or even to society as a whole, which we see a tendency in the Netherlands and France. But many jurisdictions that we investigated are somewhere in the middle. And for example, in Belgium, the interests of other stakeholders must be taken into account insofar that they impact the collective profit seeking of current and future shareholders. Also in Belgium, we see that the Articles of Association of a company may mention other objectives than just profit seeking. It may mention the environment, and then it must also be taken into account by directors when they set the strategy of a company. Another example is Germany, where the directors have to take into account the interests of creditors and employees of the company, but they need to base their decisions on the company's interests. But the general trend out of all of this is that the duty of care should evolve together with the EU sustainability legislation, with sustainability being integrated in the duty of care standard for directors. When the legislators want to integrate sustainability in the director's duty of care, their main focus lies on the fault requirement for civil liability of directors. A director then commits a mistake when he or she does not act in the company's interests, and this interest could also include sustainability matters. However, and this is, I think, the really important point that we wanted to come across, is that effective enforcement of sustainability legislation requires a full liability framework that goes beyond the mere fault concept. And our survey has shown that there are many diverse liability frameworks in the various jurisdictions. We see different rules on damage requirements, on causal link, on burden of proof, on how to make a derivative claim, how to initiate tort liability cases, and so forth. And we have identified interesting examples of this divergence. In Romania, for example, a director is only liable when the director acted outside the limits of his or her mandate, which is much more limited than just not acting in the company's interest. Some countries have a higher threshold for third-party liability claims. For example, in the Netherlands, a director can only be held liable if he is seriously culpable. But in Poland and Slovakia, they can only sue directors if the enforcement against the company was ineffective. So it's sort of a subsidiary liability. You first target the company, and if you're not successful, you can go to the directors. And the last observation before I turn to the CS3D specifically is an element that is often overlooked when people discuss directors' liability and sustainability matters. And that is the liability of directors that is specifically triggered because they took into account sustainability matters. And in most jurisdictions, we see that the law does not distinguish between the cause of the management error. The management error that results from sustainability is treated the same as a management error that has other causes. So in other words, if a director takes into account sustainability when setting a company's strategic direction and a business plan, for example, and if that would result in near-term financial losses, losses that could even risk the insolvency of the company, and shareholders or creditors could hold such a director liable and successfully liable, precisely for having implemented non-profitable sustainability measures. And it's just not theory, as shown by, if you look at what happened with the CEO of Danone, for example, Emmanuel Faber, who was under pressure by one of the shareholders and is then removed from his position because of the deteriorating financial results, notwithstanding his efforts in directing Danone's strategy towards more sustainability and ESG legislation. On the next slide, then I turn to CS3D specifically and the impact on directors' liability. 3 points are highlighted here on the slide. So the first one is that the CS3D introduces a new source of liability for directors, because as I already mentioned, they could be held accountable for the company's compliance or non-compliance with the CS3D obligations and standards, as well as for the harm, for the damage caused or contributed by the company's CS3D failures. Second point is that the CS3D is expected to have an impact, and I already mentioned, on the director's fiduciary duties. So it requires it to act in the best interest of the company and its stakeholders, and it must take into account CS3D risks and obligations. It must exercise due care, skill, and diligence in overseeing and implementing the CS3D policy and processes. A third observation here is that the CS3D likely will increase directors' exposures to claims and sanctions, to reputational damage, to financial losses, but also to ethical and moral challenges in relation to the CS3D responsibilities and decisions. We can imagine that there will be some conflicts between complying with the CS3D strictly and the profit-seeking goals of the company also on the near term, and I'll come to that. On the next slide, we referenced the articles that are currently proposed that relate to directors' liability, but they are likely to be removed from the directive, and I'll come to that. Article 25 is the article that really refines the duty of care obligation, so that directors should also take into account the consequences of their decisions for sustainability matters when they are acting in the best interest of the company. So redefining the duty of care obligation, taking into account and redefining the interests of the company. Article 26 obliges member states to ensure that directors are responsible for putting in place and overseeing the due diligence actions and policies that are referred to in the directive. I would like to end here on the next slide, by making 3 observations when we talk about directors' liability and the CS3D. My first observation is that Articles 25 and 26 of the CS3D, whether or not they remain in the text or not, are likely to be insufficient to create an effective enforceability framework. The proposed text, the currently proposed text, merely obliges directors to take into account sustainability matters when they act in the company's interests. And as I've explained, there are divergent directors' liability systems in the EU, which will, in our opinion, strongly mitigate the increased liability exposure for directors that is generally expected to happen under the CS3D. So that's the first observation. Second observation is that Articles 25 and 26 of the CS3D are likely to be removed. We noticed that the member states considered Articles 25, the duty of care, to be an inappropriate interference with national provisions on directors' duty of care, and that they can potentially undermine the director's duty to act in the company's best interest. And as a result, the Council of the EU envisages the deletion of Article 25, but also Article 26. And it's likely that the main elements of Article 26 will be moved to other provisions in the directive, the provisions on integration of the due diligence in companies' policies and the risk management systems. My third and last observation is that the CS3D will undoubtedly contribute to effective corporate social responsibility towards directors. So the CS3D obligations will, in our view, undoubtedly influence the broad and flexible duty of care that is applicable to directors. It will require directors to effectively implement, take into account CS3D requirements. but it remains to be seen how the case law will develop. We currently see and identify a rapidly evolving precedent-setting case law. If we look at, for example, what happens in the UK, but summarizing, it will, in our view, have a considerable impact on directors' liability. But we also wanted to give you a bit of good news in the sense that it still remains to be seen how effective the enforcement will be and whether there will indeed be an uptake on directors' liability cases in practice. Thank you.
Thank you very much, Bart. I think we now move in the time that we have left to a discussion, and I will open the fire by asking one or two questions myself, but you are requested to put your own questions on the chat, on the chat facility, which you can find easily on Zoom. Now everybody is more or less familiar with Zoom, so we can do that, and we'll look at these questions, and we'll try to find an answer. Before I move to the first question, which is on the chat, waiting for the others, I will turn to my colleagues and ask them what room do they think that when this directive is enacted, the member states will have in terms of transposing the directive. Because Bart, you mentioned that there was a wide variety in the scope of the implementation of the current regimes of directors' liability in the various states. And are we likely to see that again if and when the directive is adopted? And whether there will be states which are going to be more zealous than the others and go further in their transposition of the directive. And perhaps previous experience can help us of other directives can help us answer that question. I don't know. Is Gauthier? Do you want to take that one?
Extremely happy because I can give the perfect lawyer's answer. It will depend. Now, there's a few elements. On the one hand, and if you look at the Commission's proposal initially, the proposal of the Commission had the intention to be fully harmonizing. Fully harmonizing means that irrespective of the legal basis, it means that every member state has to take over the essential of the directives, not only the essential, but the exact part of the directives in its own legal system, but obviously only a choice as to sanctions and what legal instruments are used to need to implement the directive. And so when you have a fully harmonizing directive, which was the purpose of the Commission, it means that all national legislations defining obligations will have to be the same. And so there is no room for gold plating or any other sort of plating. But on the other hand, why does it depend? On two reasons. One, you see that with the works and the views of the Commission, the Council and the Parliament, that fully harmonizing idea is crumbling away. And on the other hand, even in the initiative of the Commission, Bart identified a few issues in Article 26. I've also talked about a few issues in Article 22 that are not regulated, and consequently, there will be, not even with the current text, no full harmonization. And there you will indeed get the question about maybe not gold plating, but specifically you will with the question, are there more interesting fora than others? I think also if you look at what Bart explained on the several types of liability you see in member states, it will be potentially, depending on whether you can sue a company in more than one country, you need to look at what the trend in that national legislation is in order to identify directors' duties, which may go beyond one country to another. But the ultimate question, the ultimate answer is indeed, it will depend whether or not the current level of harmonization or the aspired level of harmonization will survive or further crumble down.
Thank you very much, Gauthier. And indeed, it may become one element about other when you choose a jurisdiction where you want to create a new company. For instance, in the case of joint venture companies between different between companies, between different jurisdictions. Of course, it will not be the only issue to be dealt with. There are considerable tax and other legislation matters to consider, but that may become one. If I look at the questions which are on the chat, there is one. The first one is you mentioned that, and that's I suppose it's referring to what Bart says. You mentioned that directors can be held accountable for embedding sustainability in the business strategy. Should it be argued, in that case, would it be obviously a defense to say that you would have been held liable for sustainability if it was not embedded in the strategy, even if it's leading to financial losses? So you, of course, have a very difficult balance of interest to weigh on both sides. I don't know what you think of that, Bart.
Well, definitely, that's exactly a bit the goal of the legislation, is that you can indeed be held liable if sustainability is not embedded in the strategy. I think that's what typically is the first conclusion you take from this directive. So absolutely, yes.
Yeah. So for more than ever, the directors will have to play a very sophisticated balancing act in all their decisions.
Absolutely.
So second question is, I think it's probably easier to answer. Are we talking about the potential litigation based on the directive or based on national transposition? Well, I think, again, well, I don't know, maybe Gauthier, you want to take that?
So the directive itself,
yeah.
So it will not be based on the directive. It will be on the basis of the national transposition.
Yes.
As I said on your previous question, how far or how different that national transposition will be in the member states will depend from the ultimate text and the harmonizing effect of the directive.
Yeah. Yes. But of course, the directive is not a regulation, and therefore it doesn't apply directly. So it will depend a lot on the local transposition. Another question is a CSRD supposed to replace all the other types of due diligence regulations that exist in Europe? Gauthier, over to you again.
It's an extremely relevant question, and it's actually one that's keeping me literally awake at night, and also some clients, because there is overlap. I mentioned deforestation, conflict is very specific, batteries, but specific deforestation and the CS3D, there's overlap and sometimes incoherence, and so there is no clear answer to that. It's not as if the other types will be all of a sudden superseded, but the question on aligning the efforts that companies will need to do for the CS3D and for batteries and conflict minerals are very specific, but the huge sector, or the huge number of sectors which will be touched by the deforestation regulation, that will really require, I think, also some alignment and some guidance by the Commission if and when the CS3D would be adopted and enters into force. Because they do exist currently, or the idea currently in the text is that they exist next to it, one to another.
Yeah, well, the only thing is that the existing legislations will have to be made compatible with what comes out of the directive.
True. Yeah, absolutely. And that is an element. I apologize. It is true that if a directive is fully harmonizing, the French vigilance law, the Belgian proposal, whatever Austria would do, will need to be in line with the material obligations as in the directive. So sorry, I didn't see the member states' perspective. Sorry.
The next question is a short one, and I think I can provide a short answer. Are we talking about directors? Are we talking about executive or non-executive? Well, the answer is both, because if you have to look at the definition, or at the beginning of the draft directive, there is a definition of director, which is a word which is not very easy to translate into various laws, and it is a very broad one. I think that everybody in a senior position in a company can be encompassed in that definition. So the answer is yes, it will include the executives and non-executives. And by the way, we said earlier that in the current situations in Europe, in most cases, the definition of liability is the same for executive and non-executive. Unless you have anything to add, Bart and Gauthier, I'll move to the next question.
Fully concur.
Yeah, because we have precious little time now. How far a due diligence process is intended to go through? How can the company be protected in case of suppliers cheating during due diligence? Bart, perhaps it's for you, the use of what you know when somebody has cheated on you when answering your bona fide questions.
I was actually more looking at Gauthier for this one, because it's more in the sense how the due diligence requirements are being set in the directive, and also look at how the civil, it's more the civil sanctions that apply here, the civil liability of the company itself, not so much on the director. So maybe Gauthier, if you have some thoughts.
The cheating point is a very difficult one. I think on the one hand, the directive will fall back on a number of existing best practices. There's a number of OECD guidelines on how you do in international organizations due diligence, which also depends not merely on ticking the box exercises, but a number of also active obligations. Also, monitoring control of your own supply chain will be part of your obligations. Against pure cheating, that is, would literally be forging data. There's nothing in the directive, and there I would assume it will be under general civil law. Can you be held liable indeed for somebody else's cheating? But the due diligence is not a mere paper exercise. You cannot just say, I send some clauses to my contract partners, or I ask them to fill out a questionnaire, I'm safe. It really is a bit more far reaching than that, and it will require active role and intervention and scope and I would say measure setting in conferring with third parties, with NGOs. So again, there may be some protection against cheating, but if somebody really cheats, I think there's nothing the directive can or has in stake for that.
Well, thank you, Gauthier. While you're on the air, another question which I think you already answered in your presentation. When can we expect the CS Treaty to be enforced and or accepted by EP? I think that the key answer is when the elections are looming.
Yeah, so the current thinking, and I think the all parties or the co-legislators are working to having a final adoption of a text by, say, late of this year, but also vote in Parliament. And as the last vote in Parliament will be somewhere in February before the elections. That is one element. The second element, when will it enter into force? The directive will enter into force 10 days after publication in the official journal. But more importantly, when will countries, member states, have to implement those rules? And there's a staggering entry into force in the directive. It's 2 years, well, again, depending on whether you look at the Commission or the Parliament's proposal, but let me go with the Commission proposal. It is 2 years for the large companies, and it is 2 + 2, so 4 years for the smaller companies. So they really make a difference between type in the scope of the number of companies that would be in scope, but not in the type of obligations. And so, but still it would be, supposing it's adopted early 24, that would then mean that the obligations for the biggest group of companies or the biggest companies will start in 2026.
Yeah, thank you. The next question is it's a more difficult one. Should directors be more cautious about accepting board positions in EU countries with harsher rules around directors' liability? That's not an easy question. My view is that it has also, there is a twin question to that, is our board of directors be more cautious about which countries they want their companies to make business? Because there will be places where the likelihood of having the answers to your due diligence questions will be a lot more difficult to chase and obtain. I don't know whether you guys have an answer to that vast question.
But I think it's there is a valid concern in this question, and I think it's a logical question. And for me, it's also a little bit a discussion with your D&O insurer. How will insurance companies, so D&O, direct liability insurance, will treat this new wave of regulations? And it's probably a discussion you can have when you are considering to accept a board position, given that there is a whole lot more duties that you need to take into account with when you accept such a position. So it's definitely logical that your probably directors shall be a bit more cautious. On the other hand, it's also a question of risk mitigation, and in the world full of risk, it's exactly the type of discussion you need to have.
Well, a time when you could take a directorship lightly in order to enjoy the company of colleagues or friends, it's over. It's getting more and more a serious business. In the last 5 minutes, I have two questions. I'll start with the more technical one. Well, three questions, sorry. I'll start with the more technical one, and I will then go to the broader one. With the collective redress, the whistleblowing directive, the corporate sustainability reporting directive, and a national civil liability framework, can it be considered that the building blocks are already there and the CS3D is superfluous anyway? Well, Gauthier, what do you think of that?
Oh, I can only give a political answer on this one. From a legal point of view, I think the answer is no. That doesn't mean that I agree with anything, but from a legal point of view, what the CS3D does is really requiring companies to look at their impact throughout their whole supply chain, identifying issues, mitigating issues. So it really cuts through the whole supply chain. None of these, the CSRD is a difficult one, but because the CSRD also relies on due diligence, but the CSRD will only require you to report on how you do due diligence and how you have used due diligence to define your governance or your materiality assessment, but it doesn't require you to do the due diligence. So from that point of view, the CS3D is like the twin sister from the CSRD, and it doesn't the other directives that don't cover all elements of the CS3D.
Yeah, I think it goes at least a big step further. Yeah, and we have two questions to finish. Another one coming up. I'm not sure I will have the time to go through it. An interesting question is, materiality will play a role is looking at and judging the profitable or non-profitable sustainability. What is your take on harmonizing this evaluation in the EU in the near future? And perhaps Gauthier, again, from what your reflections have gone on the implementation of the CSRD, which gives us a point of comparison, because that's where materiality has been discussed at length.
So I think the longer answer requires us to look at CSRD and look at the ESRS, so the Environmental Sustainability Reporting Standards, which are enormously detailed and hugely complex and require an enormous effort of a company to come to all the elements. There you see very, very pushed, very far-reaching harmonization. My personal take is that the appetite to go through a similar or even a reduced exercise in the area of, I would say, more the actual obligation, so really in the areas of the CS3D, there the appetite is very limited. You see it from the discussions on the CS3D itself, that it'll get dragged through the parliament anyway, but also with the new mandates for the commission in 2024 starting, I think from those leaked documents from both the council, I haven't seen a leaked document from the parliament yet on what the priorities are. None of the priorities really talk about sustainability, but talk about energy supply, safety. And so my educated guess would be that the appetite is low to come to harmonizing of what this non-profitable sustainability in materiality would be outside the CSRD in any case.
Thank you, Gauthier. I think this does answer the other question which was on the chat. How does the directive correspond with CSRD? And finally, to take the last one, which is also a very broad one and which perhaps would require us to have a crystal ball. What is expected to happen with the three proposals? Will from the EC, the Council, or the EP? Will one be chosen, or will it be a mix of the three proposals to make a directive?
It is. I think there's no other word than horse trading. It is really. Yeah. With the three lines. So at the end of this, so I used the three EC, EP, Council, and actually in the final text there will be a fourth column. Is it then the compromise? And the word says it all. It's a compromise between the three positions. The Commission needs to try to broker deals, but it's really sometimes a really matter of horse trading with public interest groups weighing on it, or NGOs weighing it, on companies weighing it. So it's not just picking one of the three, it's really negotiating every open point, and there's a lot of open points on this proposal.
Well, thank you very much, Gauthier. I'm sorry, but we were committed on 1 hour, and I think we have to bring this to a close. Sorry for those who still have questions, but I expect that they can be sent by email, either to ecoDa or to Alan and Overy. And we will have a further opportunity to dialogue with you when we release the survey, which, as said before, is expected to be happening in the next few days. And then we'll get in touch with all those who have registered for this webinar, and that will give us an opportunity perhaps to start an exchange of questions and answers and opinions on the chat. Thank you very much, everybody, again, both Bart and Gauthier, for your very enlightening presentations, and for the many people who attended and stayed on this austere legal discussion. And I wish everybody a very good weekend and relaxed after all these ominous predictions that we made on the future of directives. Goodbye, everyone.
Thank you. Pleasure.